And it's more than just yielding 50% or more of your net worth. It's also the transaction costs associated with that decision. When I say transaction costs, it's like if you buy a house, you pay a commission, if you sell something, if you sell a business, you pay a commission, a transaction fee. If you get a divorce, the transaction costs on both sides of the table come out of the same pot. So whether it's technically the husband paying or the wife, it's probably coming out of that pot, directly or indirectly.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome back. This is another episode of Life's Third Act. We're picking up with Part 2, talking about Hulk Hogan. Now, those of you who have watched Part 1 know that we discuss mainly his life, his marriages, and some things relating to his success. And we wanted to save the part where we talk about his death, his estate, and things relating to that primarily for the Part 2. So that's what we're going to be doing today. You don't have to go back and watch Part 1, but I think that it'll benefit you. But if you don't want to, just stick with Part 2. You'll be able to follow it easily. So that brings us then to talking about, let's see what estate planning had been in place. So I had one of our offices in Florida obtained for us some of these documents, which some things were not on file yet that I know are at the courthouse, but they're just not showing up there in the records area that we can duplicate. So we have on the certificate of death, though, nothing surprising. It does have this provision, though, for cremation, which I know that this has not been carried out because the family does have concerns about whether there's been malpractice here. We'll talk a little more about that in a few minutes. So we did find that there is a will that has been filed, although it's not the latest version. Apparently, the will that Hulk Hogan he created in 2016, which you'll remember is during the course of his second marriage. That will had 5 codicils. Yes, 5 codicils. There was an amendment made in another amendment in 16 even. So the will was signed in 16. Then there's a codicil in 16. Then there's one in 17, 21, 22. Then there was in 19. So there's 5. There must be some difficulty in obtaining this original signed document, though there's no question that it's there because the codicils confirm this underlying will. And we don't have a lot of information. All we have are what is stated in documents filed with the court. But we do know that there wasn't, at least as of a couple days ago, an actual personal representative formally appointed. And remember the role of the personal representative whenever you have a will. A personal representative is a person that follows up, does everything that needs to be done in the case. They're the people that will file suits. They will locate assets. They will secure the assets. They will identify heirs, identify creditors who are legitimate, people who have claims. They will sort through those and determine their genuineness. They will also try to pursue any claims that the estate has. See, there might actually be the estate is in a position to bring causes of action, people who owed the decedent money, Hulk Hogan money, and yet it wasn't paid. Or it could include people who did him wrong, wrongful death claims. So these are all roles, important roles, that a personal representative plays. It's a very responsible position. And we said on here before that you want to pick carefully the person for that role. You could just name anybody in your household that you trust, but you have to assume if you do that they're hiring a very skilled law firm, that they have a lawyer then who's capable of doing all these things that have to be done in this role. It's an important role, especially if you have more assets. It becomes more complicated. And in this case, there's no question that I don't think there's any question by any of the heirs that it was Nick who was to be named as personal representative, along with apparently Terry McCoy, who is a friend and a lawyer to Hulk Hogan. Knew him for years. They had a good relationship. And he's presently, according to these documents, trustee of this revocable living trust, which was created in 98. So in 1998, there was this trust that was created, a revocable living trust. Many of you have one. It was created when Hogan knew he had a couple of kids. The kids were still not adults at that time. He must not have expected a divorce was going to occur 10 years later. So he at that time started putting assets in this, and we don't know what all those assets are. And we don't know that because with trust, none of this is made public. We do know the bulk of his estate, and it is significant, is inside this living trust. So whenever we look at the assets that are listed in an inventory, for example, associated with this will, then it's not going to include all these assets that are sitting in this trust. And we know there's real estate. There's 3 or 4 properties that we know he owned apart from, in addition to his home. And these are not named in the will. So we're pretty confident that these are things that already exist in the trust. However, he still, though, created a will because he wanted to allow for personal property, personalty items, as it's called. That's anything that has a tangible form to it, whether it's a table or whether it's memorabilia, collectibles, whatever it might be, jewelry. All those things are examples of personalty. Personalty can add up, especially with celebrities, to a whole lot of money, as many of you will recall, like with Conway Twitty and many of the people we have talked about. The personalty, the collectibles, and other things in their life, including awards, trophies, things like that, are very, very valuable.
And he had a lot of them.
Yeah, will become more. And as you point out, he has a lot of those. So he did include discussion of those items in the will. But anyway, so Nick filed the will. Nick is named as a co-personal representative. And apparently, because they haven't found this original of a document, I think it was the original of the will, we just know that part of the document they need in order to prove this up, which is in addition to the codicil, they need to have the original will. And if they do it that way, they also need the codicils in between. So you can still, though, have a will proved up about that, but you have to establish that it wasn't intentionally destroyed. There's always that suspicion, because one way you can void a will is to just tear it up. So if you've created a will and you don't want it to be valid anymore, if you tear it up, then the court will presume not that it's lost. The presumption will be that you tore it up. But if there's evidence that it clearly existed and that you did not tear it up, if there's some additional evidence, such as codicils, if there are additional evidence that shows, no, this was not what would otherwise be assumed, it'd be assumed it was destroyed, not lost. And in this case, we have the codicils. So I've seen nothing in the record to reflect any objections relating to whether or not what is believed to be in the contents of the will are, in fact, different from the contents. There's no allegation of that nature. So it's just a matter of finding, though, this original, if it exists. If it doesn't exist, they're going to have affidavits about we saw it and this is what happened to it or didn't happen. That slows things up. So what happened with the filing of the will was that the lawyers representing Nick and I guess the estate, they have asked for the appointment of a curator. And a curator is kind of an interesting role. It doesn't exist in the state of Missouri, but it's not uncommon. In Florida, you have a curator, who is a position that is to come in on a temporary basis, like a guardian ad litem or a temporary order might be ordered for some emergency situation regarding someone's health, et cetera. So in this case, you have a concern that the assets will become wasted or will somehow depreciate. The estate will be harmed financially if there isn't action taken quickly. So there was a document filed for an emergency restraining order, and that document a judge approved. But in order to get it done, you had to have the person, in this case Nick, who states that he is to be appointed the personal representative, but he can't do that until we have these other documents accounted for and proved up for purposes of opening the estate formally. And so what he's done is he's asked the judge in the probate court to go ahead and appoint a curator. So the court has done that, and that curator now is in a position to do two things. Both of these things were raised in the pleading to the court. One was there is a cause of action that can be filed for medical malpractice. So this is how we know this is coming down the pike. So it specifically mentioned that the intention is to bring a medical malpractice action. And we need to have somebody who can act now because the value of this suit can go away if there's delay, if we're a few months getting this formally appointment of a personal representative who, again, would normally have the powers to do all this. Personal representatives those are who you think about doing all these things. And when I say personal representative, sometimes a few states will still call it an executor, so I don't want to confuse you. Executor, personal representative. But these are the people who you think of taking care of pursuing things that increase or preserve the value of the estate when somebody dies. So here we have this concern about is there going to be evidence that's going to disappear relating to this alleged malpractice? Maybe. I don't know. And there seems to be concern. So, in order to put together a case where there's an allegation of malpractice, it does mean that you've got to get experts. You have to get a copy of all the medical records. You have to pay this expert to review it. That's not cheap. And this expert will look at all that evidence. It means perhaps going ahead and if you file the action, it means you can then go ahead and start getting depositions, protecting the evidence that's there, because strangely enough, many of you will not be surprised to hear, evidence tends to go away. Employees no longer work there. People no longer remember. Doctors, their records somehow are not as clear.
Yeah, recordings get lost or found later, right?
It's just, I think that I don't know if there's a specific concern that the family has, but they do seem to feel they've got to get this filed urgently. It's not a statute of limitations issue. I'm sure they have in most states you have at least 2 years on a malpractice case. And if it's something that you wouldn't reasonably discover, it can be told. TOLLED, told until such time as you should have reason to know that the malpractice occurred. So in this case, it's not a statute of limitations that's pressing against it. So I think they feel, though, that there's some concern about the evidence maybe disappearing.
I believe there is a recording of the police talking to an occupational therapist.
Yeah.
So.
And so we can't, and now apparently they can't find this occupational therapist, the last thing I read.
Okay. Something's coming out probably right now.
So and the other thing, let me mention it, then we'll come back and talk about these concerns. The other thing that's mentioned is there's a sense of urgency because there's in place right now an emergency restraining order regarding anything that's recorded in the sex tape that we mentioned earlier. So a federal judge, and this is a federal matter because it relates to constitutional issue privacy. So this federal judge had issued, just based on very preliminary evidence, an injunction forbidding this information, this tape, to be included in a documentary that's being created about Hulk Hogan.
Yeah.
And it is a major network that, not a major.
It's Netflix.
Netflix.
Yeah, so because Bubba the Love Sponge is wanting to put this, he's got this documentary and that's what they're waiting on. It's been froze.
So I think that their basis is believing that the underpinnings of this ruling against them years ago in the federal court was that it was a right of privacy of an individual. Well, this person's gone now. So then it became, doesn't that make moot the requirement that we not publish this? Can we not do it now? And I don't know how the law, this is outside my area of practice, certainly, but apparently there was the intention to go forward and include this as part of this documentary. And there was a great sense of urgency on the part of the family to be sure and get this new restraining order in place. But restraining orders, when you run in and get a temporary order, that was only good until early September. So they don't last for long, often like 15 days. And the reason is you don't have the other side there. So the good news is if you need to get an emergency order protecting you regarding the release of information such as this, for example, that once released, it's not fixable.
Yeah.
So a judge, if you allege the necessary information, if what you allege without proving, because you don't have a chance to prove it, but you allege it under oath, if a judge believes that truly irreparable harm will result, then a judge will go ahead and grant it. So that's not unusual for a judge to grant it. But to protect the other side of the table, that typically is not even there because you kind of ran to the courthouse. So the protection for the other side is to say, look, yes, you can be inconvenienced for 15 days or 30, whatever the temporary order is. But then you get your day in court. In other words, it expires without setting up a full hearing in the meantime to present the necessary evidence for the gavel to go down in a permanent or quasi-permanent way, saying this can't be done. Well, they got the temporary order already, so now it's about to expire. And that's the reason that they have to have somebody go in who has authority to be to represent the estate and has the authority to argue this. So those two reasons given, a malpractice concern as well as the issue relating to this sex tape. And the court granted. There was a letter to the judge written by counsel that was representing Nick and Terry. And this counsel, who I assume knew the judge, is local, Raleigh Green IV. So he wrote, Judge Campbell is the judge in this matter, and explained these facts and said, we need this appointment immediately. And I see where the judge looks like that very day. He just granted letters of curatorship. So now you have appointed, whereas Terry Belia, resident of owning assets in the state of, he's the Hulk Hogan, and then Terry L. McCoy is appointed curator of the decedent. So it's Terry McCoy that got the appointment. So it wasn't Nick too, it's Terry. And so Terry now has the ability, pursuant to this order, now he can immediately go and seek this protection. So the actual malpractice suit has not been filed, at least as of yesterday, but I do expect that to be filed. Incidentally, I'm looking here at the replacement first codicil of the last will. We'll talk a little bit about that contents in a minute. Let's go to the malpractice here and look at what we have. So apparently the allegation is that there was a neck surgery that was done in May. And this was supposed to be a minor surgery. I think it's minimally invasive surgery. So normally you think of a small wound, small entry. And yet, according to, I think it was this therapist that you mentioned who was there at the house at the time and had been with him for some time, alleged that this phrenic, and it's spelled Phrenic. I'd never heard that phrase, phrenic. So the phrenic nerve was severed, and this nerve is apparently what allows you to move or for your body to communicate with your diaphragm
and your brain together.
So if it were severed, then he wouldn't be able to properly breathe.
Exactly.
And that's what the family is alleging, and that apparently, though he died 2 months after the surgery, they believe that it was a chain of events that was set in motion by this severing of this phrenic nerve. Now, this is just an allegation, but they appear to have some authority supporting this theory, and that over time they believed it caused hypoventilation, which is a reduced ability to breathe. And then there's also, we expect it to be allegations regarding the postoperative care. They suggest that the drug administration mistakes, lapse in professional conduct. District 6 medical examiner listed the cause of death as a heart attack, but the family felt that it was resulting from his inability to breathe. So we don't know where this is going.
It's going to take some time, though, I'm sure.
It's going to take some time, and it could be a substantial award, because despite everything we said about, in some ways, his earning power in the last 10 years of his life was less. In other ways, though, he continued to grow into this sort of statesman figure after he was readmitted, having been in the wilderness and whatnot for relating to these scandals. But he had sort of regained his position as an elder statesman in this sport. And so he definitely had the ability to earn additional money. And the way you calculate damages in a case like this is you do look at what would have been the economic impact to him and by implication to his loved ones, his survivors, by his having died 10 years, for example, earlier. Would he have lived additional 10, 15 years? I think it's reasonable to argue at least 10. So what was the economic impact of that loss of income, including the appreciation of assets that were there at the time, that would have been there at the time. So it's not an easy thing to settle. A wrongful death action can be brought by the estate. So if you die as a result of malpractice, for example, or just a reckless driver on the highway, then the good news is that if there was negligence, there can be an action brought by your estate. Now, if it's an action that relates to damages associated with being deprived, reducing the net value of an estate, being deprived of income, that's going to be a cause of action that's really going to just exist through the estate. Now, occasionally you'll hear about what in Florida they call survivors. Survivors can have a cause of action. A survivor is defined as a spouse, of course, but can also be children. And if they're minor children, then that action will come through, in all likelihood, the spouse. But adult children theoretically could bring an action, but it's not going to be related to that loss of economic benefit because the estate is really the representative of that. Those are causes of action that relate to other less tangible factors that can relate to that relationship that you lose when someone who you really care about dies. That doesn't represent the sort of significant value that is derived through the estate for a cause of action that typically these same people, these survivors, quote unquote, under the statute, are typically the beneficiaries through the estate anyway. So the primary means of compensation comes through the estate. So that's the reason that this was a rush to the probate judge to appoint the curator, and then a rush to get this filed with the federal court in order to get this restraining order made a permanent restraining order regarding the sex tape, and then also to be able to file an action and commence discovery on the malpractice claim. Remember, you can't really do discovery, quote unquote, until you filed an action. And then you have the authority to start demanding copies of records and demanding this and demanding that. You can't do that in the absence of a pending case unless you're the individual and you're wanting your own records. So those things have gone on, and I want to get back to the documents. So the expedited petition for the appointment of curator, that was granted. When I was telling you about the last will a while ago, it's funny, what we have here is the will that, it's odd. It mentions his wife as being Jennifer, and Jennifer, you'll recall, is wife number 2, not wife number 3. But at the time this was signed or executed, was 16. So it doesn't make this invalid because that's the reason that you have codicils. Codicils allow you to avoid creating a new will. And it's not just about creating a new will, it's about having to date back everything. So if the fundamental plan you had was good when you made it, and in this case it apparently was in 16, then it's just a matter of making the necessary amendments thereafter and keeping the original will. The problem is, and in this case is an example of it, you have to come up with these prior documents sometimes if you don't have evidence of the original document with the codicil. So we don't know the details of that. We just know that obviously it's an issue locating it because we still don't have this appointment of a personal representative. And yet I believe from the tone of these pleadings that there's no question that they're going to find this. And another thing that I'm told was in the most recent codicil, and I've seen nothing to dispute this, is that Nick is the sole beneficiary, which seems odd, but it's not as odd as it seems. Remember, this wife was a wife of 2 years. So when you have a wife of 2 years, she does, well, a wife of any number of years, she has the right to take what is considered a spousal election. A spousal election means that she gets to claim some percent based on statute, just by virtue of being a wife, whether she was a wife for a year, a day, or 50 years. And that's one of the flaws with these spousal elections that have existed for a long time in this form, but in recent years have been modified in a number of states. Some states have gone back, as Tennessee did, in order to correct this, now calling it the Conway-Twitty Amendment, And they've looked at their spousal election statute and they said, we need to have a sliding scale based on the length of the marriage. Yeah, beyond a certain number of years, you would presume 30 or 33%, a common percentage in these statutes. You would presume it under those circumstances. But would you presume it if somebody's been married for a couple years and they have adult children?
Yeah.
So in this case, sadly, I thought Florida had amended theirs, and I got a copy of the statute. And the statute indicates that it's flat. It's a flat percentage. It's 30%, and it doesn't matter how short the marriage is. So it's not surprising that she wasn't mentioned here. So she has to make an election if she wants something out of this will. But here's what I think has happened. I suspect that we've talked about the revocable trust. I think the revocable trust had a provision for her. It was amended a number of times, just like the will has been amended. And I suspect that it says in there exactly what she's to get. It probably is pretty generous. And another thing is, remember, the definition of what a spousal election does applies to, yes, it can apply to some assets that are not technically in the estate. And remember, there aren't any significant assets in the estate for the most part. I mentioned the personalty. So yes, there are some things, and I'll talk about those. But for the most part, anybody who has a living trust, they're going to have a lot of their bigger assets probably in their trust. So in this case, if she chose to take the election, then it might be that what is said in this trust, I'd be willing to bet, is that she forfeits that. So whenever you have provisions like that, it'll often incentivize the spouse to choose what in this case would be given her through the trust.
Well, she'll also have option maybe of more money too, because his oldest daughter, his only daughter, first child, Brooke, she was not in the will. She didn't want to be in the will. Apparently, she and her father had the talk of her being left out of the will. She had been estranged back and forth from her parents, although they weren't on like hateful terms or anything like that. They very much so respectfully had disagreements.
Yeah, we don't know.
There was love there.
We don't
know
what that. Yeah, we don't know what that looked like. You're right. And when you look at the level of conflict that we commonly see, the evidence is that, and this was done incidentally. I don't think that she came to their wedding, if I recall correctly.
Yeah, well, from what I saw, she didn't. She has, been away from her dad, and it's really bothered her. Although they did move to Florida to be near her dad, but everything kind of started when he got married that third time. It kind of looked like.
So apparently, though, Brooke is financially independent.
Yes.
Doesn't mean she's wealthy, but she made clear that she didn't want to be included in this, and she's even made statements after the death of her dad that she's comfortable with this arrangement. But keep in mind, we're talking about the will that she isn't named in. So we don't have the wife named as a beneficiary in the will, and we don't have her named as a beneficiary in the will. But it doesn't mean that they're not mentioned in the trust.
Yeah.
So we don't know those details, but I suspect that they're both mentioned in the trust. And I'll tell you that as to the property that did go through the estate, according to this rough inventory that was filed by Nicholas when he first filed the copy of the will to open the estate.
Well, Linda, his first wife, she's still, like you said, like we talked about before, she got quite a lot of things. Liquid assets, I believe, 70%. She got property, ownership interest in business entities. So
yeah, we're going to talk about that. So under the nature of the assets, and this was filed in, this was filed in the probate court, and this was September 8th. And it's an expedited petition to appoint a curator. So what is listed here as the nature and approximate value of the assets in this estate are, and listed as cryptocurrency, $200,000. Significant, probably gone up a lot, and it probably was 50. Tangible personal property, $800,000, and that's very believable. Intellectual property, including what he calls right of publicity. I think he means like NIL. $4 million. That's very reasonable. He's a brand.
Yes,
I mean,
he
he's
is.
outrageous, and he rehabilitated his brand.
Yeah.
Now, if he had died immediately after the racial slurs,
Yeah, probably.
it's an example
would've-
where, yeah, the future value of his name, likeness, image, all that would be substantially less. But no, I would say in this case that the $4 million is a very reasonable number. And believe me, there's no incentive to increase the number more than. So what you would expect is the number to be low for purposes of filing a value in the estate. So $4 million there, and then it lists a medical malpractice action with a question mark. So these are assets totaling what, $5 million. I think that's conservative, and this is just what is going to be outside of the trust for reasons we don't know, but these are outside of the trust. I'm sure some intellectual property must be within the trust, but since we can't see it, we speculate. But it's interesting that he included that here as being part of the estate. So also what tells me about the intentions regarding Nick as a beneficiary. It says relationship, son, beneficiary of estate, appointed as co-personal representative. And it does not list as a beneficiary of the estate Brooke. So that tells me that the codicil that they will use, apparently the last codicil was that one. So I think it's pretty reliable that Nick here is listed as the sole beneficiary. Does list the name of the surviving spouse, but doesn't say beneficiary. So for whatever reason, it is a little mysterious to me that Hulk would choose to, even if my daughter said, take me out, I don't want it, I wouldn't take her out. But again, I'm betting Hulk Hogan. There's no evidence of great enmity, as you pointed out. That I think that Brooke probably didn't like this last marriage and didn't want a part of it, and certainly didn't want to end up arguing with Nick or with Sky about these assets, is my guess. So she just said, look, keep me out of it. I don't want to get, I've read these stories. I don't want to be in it. And and has said since his death that she's happy with this position.
Yeah, and she even named, she just recently had twins, boy-girl twins, and the little girl's middle name is Jean, which is named after her father. So again, to name your child after your father, there's love there.
I think you're right. I don't think that this was directed at him. So we have, again, the last will. What else do we have filed here? We have the appointment of the curator. I told you that. Notice of filing a temporary restraining order. That's not been signed yet. But the restraining order prohibits any action regarding disposing of assets and stuff while this case is pending. Again, we don't have a personal representative appointed yet, so the curator is the one who's going to have to hurry to assure that everything is protected while this case is pending. Replacement first codicil, we talked about that. And then we have the temporary restraining order that was filed with the United States Middle District of Florida. So this is the federal case that relates to Bubba the Love Sponge Clam.
You like to say that a lot, don't you?
Yeah, he's been enjoined intriguing as the federally registered copyright publishing any portion or excerpt of the sex tape, including any part of the documentary that was being proposed. The public interest favors immediate but temporary relief to prohibit Clem from publishing any portion, excerpt of the sex tape, including as part of the documentary. So the judge signed this, and this was the order I told you will expire very soon, as I recall.
You know, I bet Hulk never thought about when he participated in that this would live to haunt him even after his death.
Well, he didn't know. He didn't know he was being filmed. You're talking about the sex tape?
Yeah, but even after he went to court over it, thinking that was done then. And now we've got a documentary. And two, before he passed, he actually spent 20 hours being interviewed for that documentary. Now, he also had a book. I don't know when that came out, but it was Hulk Hogan, My Life Outside the Ring.
Well, it was more interesting, I would argue, than his life inside the ring. And his life inside the ring is pretty interesting, apparently.
He's just an interesting guy.
So, so where we stand now is we still don't have the estate commencing the work that it needs to commence. We have a curator who's appointed who can do some of that, but we still don't. We have a lot of work to do in terms of closing the estate, and that means that it could be a while getting started, depending on how long these lawsuits last. The estate will likely not be closed until the outcome of these lawsuits, since the estate is the plaintiff. This could be around for a while. It doesn't mean that there can't be some interim distribution if people were needing assets, but I think that we can expect this to take a while because of these lawsuits.
And I have to ask this question too, since this medical malpractice suit is now pending. So how long can they leave his body just hanging around? Because he apparently wanted to be cremated, and now they're having to wait because they have to do the autopsy. How long is that process?
Well, it's interesting that the death certificate, I did find it surprising, as I mentioned, that it shows a cremation. And I know, though, that the family now is wanting to have any further examination, autopsy, whatever, necessary to do that. And I don't know enough about, how long you can preserve a body for purposes of this, an inquest of this nature. I know you can do an inquest after somebody's been dead a long time, even after they've been disinterred. So I really don't know where that stands, except that I'm sure that to the extent that they need any additional records for this lawsuit, that they have taken the steps to preserve any access they could have. But that's completely outside my realm of experience. So I guess let's kind of summarize here. So I guess what my comments would be on the estate planning side, I think that it certainly was appropriate to have a will, and it was appropriate for that will to be largely a pour-over will, stating that those things that do land in the estate that aren't in the trust ultimately get distributed according to the terms of the trust. In other words, everything goes to the trust and then are distributed through the trust. That's a standard formula. It makes a lot of sense. I still suspect that there wasn't the sort of planning that could have potentially saved a lot of taxes based upon the exemption being where it is. So at the time this planning was done, they didn't know that we would end up with a $14 million exemption for an individual. In this case, if it's husband and wife, you can double that. And then you have this portability, which means if you don't use up the exemption when you die, your wife can take the balance when she dies. Well, this doesn't appear to be one of those marriages where that you envision that. First of all, I suspect he didn't give his wife a lot of the assets. So I don't think that there's going to be the need for that sort of portability going forward. But still, when you look at his planning at the time he did plan, in 98, he could have created an irrevocable trust, and he could have been putting assets in that irrevocable trust. And that means that those values would have probably gone up a lot more than they in fact did. But that's a different point about the management of his assets and his divorce and all those things. But I would have thought that a good plan would have had him creating a trust that's going to allow him to avoid any potential taxes. As it stands here, though, he's probably going to be below $14 million. But it doesn't change the criticism. It doesn't mean because when you do something and you get away with it against the odds, meaning it wasn't a smart call, we shouldn't sit here and applaud that, because it might tell people who are similarly situated, I don't need to do an irrevocable trust. Irrevocable trusts are not for everybody. So I'm talking about people who think that either the exemption level is going to come down, we'll have a future, say, more of a Democratic nomination or administration that might be inclined to see it come down. We don't know. We're speculating. But right now, it's secure. But people who find themselves potentially in that position someday, or they're in it now, then, yeah, they should think about it. Because what it does is, you go ahead and transfer it in at the time, and once it's inside, that's the value of your estate gift tax. You have a certain amount for your whole life, and you can go ahead and use it when those assets are likely going to go up in value later. And so they're never taxed again. So they go in at the value that you put them in at. I won't go too far in this. I suspect that many people their heads are spinning.
You said taxes, and most people are like, no.
I know. I'm not going to. So I won't keep talking about this. I try to have the show not get boring, and it can easily get boring. This isn't a problem most of you have. But I'm only suggesting there was a better way for him to have done this than to have done it like the average middle-class person would have done it. So there's that observation. I do think that many of the things in terms of his plan, they could have been included in this trust. It might be that this trust has asset protection provisions for these kids, and will have a payout provisions for these kids that will allow them to have the benefit of this money for the balance of their lives and be immune from the sort of lawsuits and other things that he experienced.
And maybe even for his grandchildren, because he has them as well.
It could be. They would have that option of leaving it in there for their children, what portion they didn't want. So we can't see those terms, but assuming those provisions are there, then the plan on its surface seems reasonable. But for people who create great legal documents, but then leave the lawyer's office and do things in the world or in their life that impair those or just eradicate their value, those are the things that don't get mentioned often in shows where you talk about estate planning. And that, as I mentioned earlier, I think that's one of the important aspects of this show that I think is critical, is that we talk about the whole picture when we talk about planning, the last stage, the last third, for example, of your life and thereafter. So let's talk about some of these decisions that hugely impaired his financial circumstances and therefore that of his kids after his death. And one was the impact of this first divorce. I mean, it was huge.
Yeah.
I don't know if he felt guilty or if he had a bad lawyer. Anyway, it wouldn't have been good because most of the foundation of his earning power occurred during this first marriage. Yes. So as a divorce lawyer, I can tell you that people who become rich, and famous with that first wife who's hung with them, I think of Glenn Campbell's example, lots of examples we've done. Yeah. They've hung with them. And then they meet somebody younger, and they decide to get
more sparkly.
married. Yeah, and it's often a very costly decision that they never recover from. Yeah. And the same would be true for executives and others who build companies. Is that it's that early period when you grow, and especially with intellectual property, like with artists, it's especially evident because their hits occur, in the span of time. Yeah. And in this case, it's a little different, but somewhat of the same. A lot of the intellectual property that was established, the royalties associated with films and stuff that he did in the 80s and 90s.
In his heyday.
Heyday. All the way up to 07 separation. The divorce, I think, was, 9?
09, yeah. So and that would have included the days of even if it makes a comeback on what we used to call as a repeat, even the reality show, if for some reason that becomes popular again since he's passed. Yeah.
So, this is a classic example where he married her when he was broke, as is commonly the circumstance in what I described to you. So he achieves all this wealth, and then he decides to leave. And I don't know if it was his decision. I suspected it was. He married this woman
pretty soon after,
less than a year later. So I think that when guys do that, and often it's guys, could be gals, it's just a huge impact on their financial life from then on.
Midlife crisis, you could call it too.
Yeah, and it's more than just yielding 50% or more of your net worth. It's also the transaction costs associated with that decision. When I say transaction costs, it's like if you buy a house, you pay a commission. If you sell something, if you sell a business, you pay a commission, a transaction fee. If you get a divorce, the transaction costs on both sides of the table come out of the same pot. So whether it's technically the husband paying or the wife, it's probably coming out of that pot, directly or indirectly. Doesn't have to, but Commonly it does. So if we assume then that the transaction cost on this was $1 million, I don't know. I mean, I'm guessing. It could be $1 million, depending on the amount of conflict. And then also the assets that have to be sold under distress conditions, often in order to adequately divide an estate or a marital estate or an estate in probate, is that it means you sell things under distress conditions that virtually always produces less money than you'd otherwise get. So there's that impact on, depending on what the assets are. Without looking at what comprise this marital estate, we can just assume there's some waste there.
Yeah. That's when regular people who are looking for a good deal on something take advantage of the people in your life that are getting in a divorce.
Yeah,
they need to sell stuff quick.
Death and divorce. There's a pursuit of liquidity, and sometimes that happens too, where the divorce goes on not uncommonly for a couple of years, and the husband especially often needs to get cash to fund things. He's setting up a new household, so all these things come together, and none of it beneficially in terms of the value of the marital estate. And so you cut it in half, and you have this person who's worked to get up this hill, and it's like you come to this point when you're later in life, your earning capacity is diminished, especially an athlete of his age. So all of his best earning years probably are gone. And so you have to, if you imagine this as a hill, you have to slide back down the hill at a time when you're least capable of climbing back up that distance now. That's what happens financially. You're pushed down to a position you were in many years ago in many respects, but you don't have something you had years ago. And that's the energy, the health, the focus, all those things that you had in those first 3 decades. You probably don't have those for your next 3 decades.
Yeah, because he was 57 at that divorce.
Yeah. Some people do. Now, there's people who are on fire till the day they die, but don't count on that in terms of your earning trajectory.
Yeah, like Tom Brady. That's the only one I could think of. It would be like that. He just keeps coming back.
Yeah, we don't know yet. Donald Trump may be an example of that. But I think that when we look at that, talking about how he's handled the balance of his life, I don't know if that outcome could have been changed. We don't know. Another thing that we can't go unmentioned when we look at his setting himself up for that last third and thereafter was, these scandals we've talked about. I mean, the one involving the racial slurs, the sex tapes. We won't go back into that, but I would be remiss if I talked about things, if I were making a list of how he planned the balance of his life and failed to mention those things. I mean, it's true he didn't plan on those becoming scandals, but it's an example where you do things, you're reckless and you're careless or just selfish, whatever the words are. So the racial slur incident, that was very expensive to him. The sex tapes, we don't know the consequences to his intellectual property from that yet, but it was definitely a problem. I should also tell you that when we talk about let me go back for a second to the divorce, because I want to, just a few pieces of information regarding the divorce was Linda received approximately 70% of their liquid assets. So at the time, he had about $10.4 million in liquid assets. Liquid, that means stocks, bonds, cash in accounts. $10.4 million. This was 2009. Plus $3 million in a property settlement, plus 40% ownership in his business interests. Remember, those were all started during this period of time. We talk about earning ability. We're not talking about just your paycheck. We're talking about businesses that you build, or song. In the case of artists, the hit songs they write, all those things that occur during that period of time, and includes companies you start. And he started several. So she gets 40% ownership in his business interests, and that included his wrestling brand, his image and intellectual property. And importantly, also as part of that, because remember the Gawker, the violation the tort, the invasion of privacy that occurred at the time that it was recorded, not when it was made public. So that means it was a marital asset. So this, what would potentially have been a $140 million asset had this company only been able to pay 30-something million. But even 30-something million that it in fact paid, this was a marital asset, though it didn't come till later. And thankfully, she had good lawyers who anticipated all these things that were the seeds of which were established during the marriage, making them at the foundation marital, but whose fruit will not be born till sometime later. So she had good lawyers. They provided for this. That suit was expected, if not filed, at the time of the divorce. So I don't know what portion she got. I assume she got 40% of that. So suddenly I'm thinking what I thought was this huge cash influx to him at that stage in his life around 2015 may have been
not so much.
May have been not so much. So this in effect means that Linda continued to be entitled to some portion of income thereafter related to any of those sources, which quite frankly was the source for the most part of his income thereafter. Yeah. I'm sure there are some new sources, but a lot of it was derivative from this early period.
Yeah, but she was supporting him, at the home, taking care of the kids, doing the thing, doing the wife thing.
Whatever she was doing. Anyway, it was these were considered marital assets. So we mentioned the scandals. Another thing that I would mention when I kind of step back and look at the planning, it shouldn't go unmentioned that there was substance abuse. We don't know how prominently it played in his career, but we know it was an issue. Putting aside the steroids or things like that, but looking at the alcohol abuse, which apparently was with him for years, he conceded that this was always an issue for him. And things that I'm more sympathetic with was like addiction to pain medications that resulted from these horrendous injuries that he had over the course of his career.
And all the operations he had. And, oh, my goodness.
And we'll talk about those in just a minute. But there was, I'm sympathetic with somebody who develops an addiction to pain medication under those circumstances. And that was part of what he suffered with for many years, especially after 2010, when he started having more and more physical problems. But he did in 2023, which as far as I know, he kept to this. He made a commitment to sobriety. This is around the time he married his final wife, Skye. And he made this commitment to sobriety, and he said he wasn't going to drink and he wasn't going to take any pain medications. So I don't know if he stuck with that. Let's assume that he did to the extent he could. He had surgery after that, so I don't know how that worked. But the reason it shouldn't go unmentioned is that these things had an impact on decisions he made. These things may explain the sex tapes, not entirely, but partially. The racial slurs. It doesn't mean that that if he had racist thoughts that the fact that he was drinking made them okay or anything like that. It's that whatever his failings were individually, the alcohol magnified it, or other drugs, whatever those other drugs were. So you just can't evaluate the way someone has managed planning for the last third of their life without acknowledging things like this that had implications or ramifications in virtually every corner of their life. Marriages, divorces, especially
Another
divorces.
Marriage.
Not so much. Well, maybe they attribute to the marriage, but they definitely contribute to the divorce. And then the scandals. So I feel compelled to mention that when I step back and look at things. And then on physical injuries, what can you say? It was the field that he chose, and it was a field that made him wealthy. 25 plus surgeries. So 12 of which were back surgeries, multiple joint replacements. All this was exacerbated by this high impact style of wrestling that he did. He was famous for these heavy bring down. What do you call them? Takedowns.
Just jumping and here and there. He's everywhere.
Yeah. So Some of you probably could explain that better than I can about how his style was as a wrestler. But I don't think these things could necessarily have been avoided. But did they have an impact on the balance of his life? Dramatically.
Yeah.
I mean, dramatically. Your ability to live out the last third of your life, if you choose a career like this,
You're going to be in some pain.
you're going to be in a lot of pain. And maybe there are things he could have done to preserve his health better. I'm not making that allegation because I don't know. It may have been that there was no way that he could have had the success he had without some of this. But we also can't fail to mention that something that hugely impacted his quality of life in the last third of his life, which ended up being shorter, a lot shorter than it should have been, included, these injuries. It was something he had to live with, and it diminished in a meaningful way his ability to live out those years that should be the best years of his life. And quite frankly, it diminished his ability to earn income now, to do things he couldn't. Whenever he had to be in a wheelchair or something, he wasn't going to go into the ring. And even at ceremonial events, as this elder statesman, there's lots of things that he could do as long as he had mobility. And there were periods of time he didn't even have mobility. And when he did have it, it was with great pain, and that may explain the pain medication was getting through these events. So it's not where you want to be. So I don't know if that could have been avoided, if he could have been as successful financially as he was and avoided these injuries. I don't know. But I'm mentioning them because, when you look at what are the major factors that seem to be problems for him in the quality of his life, I mean, we can't ignore that. That was huge. And ultimately, maybe the cause of his death were these injuries. But, when you're making these decisions in your 20s and 30s and 40s, those of you who fit that description, when you're making decisions at that time, it is worth thinking about, gee, let's see, I can do this for a living, and I may not be able to do it very long, but maybe I'll make enough money to where it'll all be okay.
Yeah.
Those are choices you weigh as a young man. You don't weigh them as an old man, or you hope you don't weigh them for the first time as an old man.
And maybe don't get married again. Maybe just date.
Well, don't get married or stay married, heaven
there you
forbid.
Go. And don't do naughty things.
So, yeah, I mean, infidelity. I sound prudish, so I try not to preach on that subject
But it is costly.
But preaching might be the right word. It is costly. I don't get it, It's just a terrible decision, and not just for financial reasons. But anyway, I could do a show and talk about the consequences of infidelity. But they have consequences not just for divorce, but for, the outcome of your life, the last third, as well as your estate. I mean, they just have consequences. But all in all, we can say, yes, he had an estate plan, and then the plan itself may not have been bad. I suspect it could have been substantially better, but I don't want to pick on him because I don't know the details of what his plan is. But I do know that he did a lot of things that dramatically diminished the quality of his life during the last 20 years. I mean, it could have been much better had he done some things differently, and we've kind of talked about those major things. And I hope that we can all learn from this show. I learned from this show more than anybody, but I know the consequences of divorce. Ask a divorce lawyer if how many of them have been divorced. I suspect not many divorce lawyers have been divorced. If they are, they really fail to learn from experience.
Do you think most divorce lawyers, once they get into it, if they haven't already gotten married, may not get married?
I think divorce lawyers would be careful about getting married. Yeah.
But I imagine so.
Yeah. So those of us, though, who did that for a living, as I did for 30 years, you really, you appreciate the importance of marriage and the goodness of marriage. Marriage is so positive for people's lives in so many ways. Look at the estates of people who are married for 40 years. Look at their relationship with their children, their grandchildren. The organized, relatively conflict-free estate that they have when they die. I mean, not that if you were married stay married to one woman or man your entire life that all these things magically happen, but I'll tell you, if you look at the statistics, the odds are dramatically better that you'll avoid the things that we talk about on this show if you pick the person you want to spend your life with. And even if you have some second thoughts later, stay with them.
Because that's just growing pains, right?
That's my closing recommendation. Anyway, so this has been another episode of Life's Third Act. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.